So the the township approved the settlement agreement with Fair Share Housing Center, and a process by law which the township needs to follow, like all municipalities, is that settlement agreement is subject to approval by the court. In this regard, and in Howell's case, every town has one, but in Howell's case, there's a court master who's a planner who reviews the plan. She participated in settlement discussions with Judge O'Brien, and she will ultimately make a recommendation to the court. It's going to be Judge Perry ultimately, as to whether or not the settlement agreement should be approved. Her name, the master's name, is Elizabeth McKenzie. It so happened, and she was appointed by the court in 2015 when Howell filed its declaratory judgment action. It so happens that Ms. McKenzie is retiring due to personal family reasons, and as a result, the court scheduled a fairness hearing, which is the hearing where the settlement agreement is going to approve, for December 3rd, because that's the last week that Ms. McKenzie is going to be in New Jersey. She's retiring and leaving, going out of state. So the court, to keep Ms. McKenzie, to try to get the benefit of her participation in this process, scheduled the fairness hearing in probably what I would call record time, because others that I've done for other communities take months and months to get scheduled. This got scheduled like within 30 days. So we gave notice of the fairness hearing as required. The clerk advertised the notice, and and as well my office sent around the notices to the service list. So we're scheduled, as we're sitting here today, for a fairness hearing on December 3rd. However, given that Howell had negotiated such favorable agreements with the developers, what I mean by that is that they had given us a 30% set aside on rentals when the standard is 15%. Given that, the court, in its order establishing the fairness hearing, ordered the township to consider approval of developer agreements with those developers, so to lock them in, so that they're going to stand by their promise to provide that 30% set aside. As Mr. Clark referenced before, my office has been in negotiations. We have 4 developers in the plan. We've been in negotiations over the last months. There's a lot of detail in these agreements. Most of them are very close. They're not quite done. We're having one substantive issue with one of them, which has which is why we weren't sure whether or not the agreements were going to be on the agenda for today. The hope is that they were. Again, not to rush something through, but to comply with a court order which said that the council had to consider approval of these agreements before December 3rd. So we're still going to try to meet that goal. That's why Mr. Clark referenced that, the council may have a special meeting before December 3rd. I will report back to Brian, the manager, as well as Jim and Joe, on the finalization of these agreements. I'm hoping by tomorrow or early next week I have those done for your consideration. And then I just so those agreements will again lock in the developer's obligation to provide the set aside that the township demanded. But I just want to finish the process, because I think there's a lot of misunderstanding out in the public about sort of what's going to happen. So the court will have a hearing in freehold, open to the world, where our planner from CME will testify as to the settlement and as to that the projects are realistic and developable and meet the standards of the Fair Housing Act. And so there'll be testimony, there'll be objections that I'm sure the developers that were not selected will file objections. They will make arguments. The court will hear from them, the court will hear from the master, and then she'll decide whether or not to approve it. Assuming the court approves the agreement, there's still a lengthy process ahead for the township. So we would get an order, if the court approves the agreement, we would get an order of preliminary compliance, meaning that the court found the settlements fair to low and moderate income households. We would get continued immunity from builder's remedy litigation. that none of these developers can sue us for trying to put in housing where the township doesn't want it. And then the township will have 4 to 6 months to consider approval of zoning ordinances, which will allow those developments to proceed that are in the plan, as well as there's going to be a townwide affordable housing ordinance, which is required, and the court will have to consider approval of we'll have to adopt a spending plan, which is how you spend your affordable housing trust money, and that's going to and the town's going to have 4 to 6 months after approval to consider all of that. And so this process is going to continue well into next year. And then after we get through that process, the court's going to have a final hearing to see what the township accomplished, and if it accomplished everything that's going to be in the court order arising out of the December hearing, then you will get a final judgment of compliance and repose, and that will protect the township from builder's remedy litigation through 2025. So and that hearing won't take place. I think the judge now is scheduling them in June of next year. And that was one from like a month ago. So you're probably looking at the summer of next year till we get a final judgment of compliance. But these developer agreements that were on your agenda are just a step in the process that is required by court order. So that's the summary of where we are.
Okay, any questions?
No, I'm just glad that we're able to set the record straight so that no one in the public should think anything secretive has happened or anything's being changed or immediately run through, or the miscommunication is detrimental to everybody, including the deals that we're trying to make to protect the town. So thank you, Andy, for trying to assist.
Thank you.
You're welcome, Councilwoman.